Okay.
So we alerted the court earlier on that there may be an unusual Fifth Amendment issue in this case arising from the law of the case. Mr. Jones has suffered a disciplinary default in this case, resulting in his inability to contest liability. The court has established during the law of the case that...
Can we just back up for a second? So the question wasn't about Mr. Jones specifically, although maybe it was getting there. The question was, if someone spread that claim to millions and millions of people, one would expect people to be damaged. There's no...
No, you're missing a predicate in there, falsely. If they falsely spread this information.
Right, but this is not talking about Mr. Jones or free speech systems. This was a hypothetical.
He's not an expert, and he can't be questioned as an expert. He's here as a fact witness. And the fact that this is an attempt to sidestep the ruling, and once again have the motion in limine be used as a sword rather than a shield. We didn't make motions in limine to limit this material, the plaintiffs did. The contention here is that Mr. Jones, the law of the case is that the court has concluded these statements were false, not because they were litigated, but because of failure to comply with discovery. We can't talk about that. The plaintiffs have earned the right to call him a liar in open court. Whether we agree or not, that's the law of the case. What they've not done is earn the right to put him in a position where he either disagrees with their characterization of him, thus running afoul of a prior ruling of the court, or agrees with them, thus committing perjury. We would go further and say that if we get to a point where an invocation is necessary, they're not entitled to an adverse inference because that is giving undue weight to
So, Attorney Pattis, what would be wrong if his answer, his true answer, how would it violate the order, is if he says he denies the extent of the damage?
Well, I don't know that that's responsive to the question, candidly.
Yeah, so, Your Honor, I think what's happening here is we had a sidebar to avoid a proper assertion. I said I'll do it a different way. And so I came back here, and instead of telling Mr. Jones that he had lied, I said if one did, that would cause damage.
Well, who cares?
Well, I think, it's got to be asked in a way that, and I don't want to tell you how to ask it, but no, let me just get it out. We're not putting Mr. Jones in a pickle, but where the jury understands that the issue has been decided, which they've been told many, many times now. So can you think of a way to do it along those lines? So here, the court has already determined that liability is not an issue. The jury is just determining damages. And so what's the question for Mr. Jones?
No, there is no, first of all, he's a defendant. This isn't impeachment on credibility grounds.
What the question is, though.
The question is, rather than ask him directly, where he now thinks, a truthful answer would somehow incriminate himself, I've asked him whether or not one would expect that if one were to do these things, it would cause harm. Now, Attorney Pattis is still free to argue at any point that the harm caused here wasn't what the plaintiffs alleged. That's what he's apparently claiming. But Mr. Jones's response to that question, if the answer is yes, one would expect that type of harm, that doesn't violate the court's orders, and it's not false. If the answer is no, one wouldn't expect that. That doesn't violate the court's orders, and it's not false, right? So either one, he can testify truthfully without violating the court's order and putting himself in contempt.
Or I don't know.
Or I don't know.
All right. So
the
how
problem
does
with that, Judge, is it's argumentative in tone. He's not an expert, and so what one does isn't what we're here to show. We're here to show what he did.
Right, but
and
that's a different. No, Attorney Pattis. How many times do I have to say when I'm speaking, you stop? You have been a member of the bar for a long, long time, and you know the rules in all the courts. So your objection was that it was a motion in limine issue, I thought, that it would require him to lie. I now hear that it's a different objection, that it's speculative, he's not an expert.
I'm waiting to finish, so I don't want to follow your order. I have been an officer for a long time. As you know, I insist on making my record, so thank you. And I'm sorry that I stepped on your question. I thought I wasn't done. What I was trying to say was the following. I objected because he's trying to get an evocation in the jury's presence, which is entirely improper, without permission of the court. I objected further because he was asking Mr. Jones a question that places him on the horns of the dilemma. In the course of all of his proffer outside the jury's presence, he's now switched it to one would expect. That is simply not relevant. That's argumentative. He's a fact witness. His state of mind about his conduct is...
I can't disagree with that, so I will sustain the objection. And where does that leave us with respect to possible future invocation?
If there's going to be an invocation, I've requested it prelude to it be outside the jury's presence so that I can argue about whether the plaintiffs are entitled.
All right, so how does that work procedurally? So there's a question. You're going to invoke on his behalf?
I can't do that, I don't think. I'm certainly in the jury's presence. I'll argue it. I'll simply say
in a
motion
civil
about
case.
evocation. Motion about evocation.
Okay. Does that work, Attorney Matty?
Sure, that's fine.
Okay. So if that happens, Mr. Jones, if that happens, just put the brakes on, okay? So that you can do it. Okay, let's bring the jury out. So can I just see counsel in the meantime? So I can count on one hand how many times I've argued for the entire career. I used to argue, and you stop on a dime. You got to do that for me. You have a good record. You have your objections.
You're right. You're right.
That's a positive note.
Look, Judge, here's the deal. I'm an advocate. I get lost in the moment. You've admonished me, and I'm working on it.
You're standing up for your objections, right?
I'm a member of Advocates Anonymous, Judge. If I warm too much to my client's cause, that's why courts are here to ensure fair trials.
We're good. Okay, welcome back. As promised, we were pretty quick, so thank you for your patience. Please be seated. The record will reflect that our entire panel has returned. Let's give them a minute to settle in. And whenever you're ready, Attorney Matty, please.
Thank you, Your Honor. You remember in your deposition, sir, you referred to, asked you some questions about Robbie Parker, correct?
I'm sorry, say that again.
I asked you some questions about Robbie Parker.
Yes.
I showed you some videos, right?
Yes.
And I showed you a video where you were